So I'm hiking up to the falls at Fall Creek Falls State Park in Tennessee. The question arises, what happens if someone falls off the falls because of negligence of this park system? So in that situation, something called Tennessee's Recreational Use Statute would apply. And what the Recreational Use Statute does is it lowers the standard of care. So if you're in downtown Nashville and you're walking down the sidewalk and it's uneven and it's got tree roots pushing up on it, like that's a defect. And if you get hurt by that, you could potentially sue for that. But if you're engaged in a recreational use like hiking or boating or whatever, then the standard of care is lower and you have to prove something called gross negligence, which essentially means you have to show that it's happened before, right? You have to show someone has fallen there before or someone's been hurt before, and therefore the state's failure or the landowner's failure to fix the problem is gross negligence. But here's the deal. Even if you can prove that, if the injury was caused by a quote-unquote force of nature, then you still lose. Because the way the statute is written, even if you are grossly negligent, you still get off the hook if the injury is caused by a quote-unquote force of nature. So I'll tell you a very sad story about that. We had a case where a 2-year-old child drowned at the Cumming Falls State Park when the water suddenly rose and these floodwaters came through and washed him away. And the thing was, the state knew that this could happen because it had happened several times before. It had happened so many times that they knew they needed to install a flood warning system. And they tried to do that. They allocated some money or sending some emails, hiring a vendor. They just didn't do it. Someone just didn't close the loop and it didn't happen. And so the way the recreational use statute prevented this family from getting justice is they said, well, first of all, you're engaged in a recreational use, swimming. And yeah, maybe there's gross negligence because the state should have installed the flood warning system that it knew it needed because other people had died there and this whole thing could have been prevented. But floodwaters are an act of nature. And so you lose. Since that case, things have only gotten worse in the state of Tennessee on this. There are cases that say if you go to see a concert in a downtown urban area and you trip and fall on a hole in the ground, it's not enough to show that that was negligent. You have to prove gross negligence because concert going is a recreational use. There's a case that says if you golf on a public golf course, same problem, right? That's a recreational use. And so you lose unless you can show gross negligence. So the whole idea behind recreational use statutes goes back to increasing urbanization after World War II. And we had all these unused farmlands, but city space was evaporating through urbanization and development. So what they did is they said, look, if rural landowners will let people onto their land for recreational purposes, hunting, fishing, then they won't be liable if that person just falls down and gets hurt. And so the whole idea was to increase the use of the great outdoors in an era when green spaces were rapidly disappearing through urbanization. But think about what's happening now. Now you go to a concert in downtown Nashville and you trip and fall and, concert going. You are engaged in a recreational use. We don't owe you a standard of care. We only owe you the gross negligence standard. And even then we can skirt away on that if we can show that, a strong wind blew you over, force of nature exception. And it used to be the case that if you had paid money to the landowner, right? If the concert ticket or the golfing, the price of golfing, that would change the deal. That would mean the recreational use statute would no longer apply. But they revised the statute to take that part out. So literally now, if you go to the Bridgestone Arena, there's an argument and you get hurt there, they could say, concert going is a recreational use. And they might try to make this argument. So that's a long-winded way of saying what happens if someone trips and falls over the Fall Creek Falls because they negligently maintain the railing. Well, unless you can show gross negligence, you're not going to be able to recover anything. Might also mention, even if you do recover anything, because we are in a state park, the maximum compensation is $300,000 as of the time of this video under the Claims Commission cap. So that's not great either, but that's better than zero, which is what it's probably going to be. And I have literally had to decline several cases of injuries in state parks because of this recreational use statute and its application to things that you really wouldn't think it should apply to, but the statute is so broad that it will often prevent you from recovering. I've turned down cases of people injured at Bonnaroo, for example. Same deal. It's Bonnaroo, well, don't owe you the normal standard of care. Gross negligence is what you'll have to prove if you're injured at Bonnaroo by a defective condition on the land, because you're engaged in the recreational use of concert going. So just watch out for this. Be careful when you leave your house and go do any of these activities that are considered recreational uses, because they will be very difficult to get compensation for, even if you can prove that the other party was negligent.